On record?
Yes, ma'am.
All right, this is D483347. Counsel, if you'd like to make an appearance.
Yes, Mark Smith, 11872, on behalf of the plaintiff, Diana Buckley.
All right, and good morning, counsel. Good morning, ma'am.
Good morning. Hello. Yes, may I speak to Mr. Thomas Buckley, please? Hello. Hello, Mr. Buckley. This is Judge Gonzalez, court clerk. We are on the record.
Good morning, sir. This is Judge Gonzalez. How are you?
Oh, all right now. Just headed to the doctor again.
Okay, and sir, if you could state your name and spell your last name.
Tom Buckley, Buchle.
And you're aware that your attorney has withdrawn from this case, correct?
I just found that out yesterday.
They have provided you information from before indicating that they notified you, sir. Do you have what is your current address?
Can I get that to your court clerk? I don't want her to know where I'm at because she comes out here to California and stalks me. She's been out here before.
Well, sir, if they need to send a motion to you or to send something, now that you don't have counsel, you have to have an address on record with the court. And if I need to send something to you, it has to be an address of record. So you can. I just need an address where we can send something to you.
Okay, we can send it to my daughter's house, 416 Mockingbird Lane. That's Fillmore, California.
And that is that F-I-L?
F-I-L. What is that, Kim? Fillmore, F-I-L-M-O-R. F-I-L-L-M-O-R-E. What's the zip? 93015.
All right, sir, this matter had been on for a status check. Additionally, counsel had filed a motion for an order to show cause regarding the exchange of the vehicle. The court would note that on September 11th, this matter was heard, and there was an order that was prepared that did not contain all the language, counsel.
Correct.
And so that language, if you're requesting the court to do an order to show cause, you need to have the language in there. It says, pursuant to the stipulation by the parties, plaintiff shall receive the Ford Taurus vehicle, plaintiff to pick up the Ford Taurus vehicle at Kim's place of employment located at 2896 West Telegraph Road, Fillmore, California, on September 12th, 2014, before 4:30 p.m. Plaintiff shall contact Kim with their estimated time of arrival. Parties shall work through their counsel regarding any issues with the exchange of the vehicle.
When the initial order was filed, it was missing a page. It has been refiled.
It has been refiled.
Yes, it was refiled. I believe it was on the 6th of October.
Can you see that?
Your Honor, she picked the car up at the Simi Valley Police Department.
No, hold on. She picked it up at Ventura PD.
I'm sorry, Ventura PD.
They were admitted to the hospital by ambulance the day that on that Friday.
Ma'am.
I didn't go to work that day.
Ma'am, can you state your name?
Kim Hochstetler,
Okay, and can you spell your last name?
Hockstedler.
Okay, ma'am, Tom is not represented by counsel right now. You understand that?
Oh yeah, no, I understand.
Okay, also, if he's not represented by counsel, in that you are not a licensed attorney, you cannot make representations for him in court. You cannot assist him here in court. I'm allowing him to appear telephonically, but you're not an attorney and you cannot give him help. You understand that?
Right.
Okay, that's not allowable. That is an illegal practice of law, and you cannot do that.
All right.
So you just have, if you're sitting there, you have to remain silent. You cannot help him. You cannot provide him information. You cannot make statements on his behalf.
Okay, you need to know though, he doesn't know the fact.
All right, ma'am.
He's a little fuzzy.
Okay, ma'am. If you believe he's in need of a guardian, then you should file something for a guardian. But even if he had a guardian would not be able to represent him in court because you have to be a licensed attorney.
Okay, he does need legal representation.
Well,
I thought the court was going to provide you with representation.
Sir, your attorney filed a motion to withdraw, and they sent it to Kim's address, their email address, because you were in a motel and they didn't have an address to send it to you, and under the rules you had allowed service by email. And so they sent it to Kim, and so you were on notice that they were withdrawing, and they said that specifically, and I'm going to get a copy of their motion, sir. And they also mailed that motion to you, sir. And basically it says in their statement here, it says, additionally, defendant is aware of this withdrawal of counsel as counsel informed defendant on or about September 15th, 2014. So your attorney, who is a officer of the court, is represented that they in fact informed you that they were going to withdraw. Additionally, they are representing that they have advanced substantial amount of work on this case on your behalf, and is unable and unwilling to continue to do so because there has been a breakdown in communication, that they were not able to work with you, sir, that there was a breakdown, and they have now withdrawn, and you are representing yourself. So at this point, sir, if you need legal representation, you're going to have to make arrangements to do that. So, counsel, it was your motion, counsel?
Yes, sir. As the court will recall, we were here on September 11th to set the trial date, discovery, and discuss potential negotiations to avoid the trial. At that time, on September 11th, the court ordered that she would be entitled to go to California and pick up the parties for divorce. I believe it was defendant's daughter represented that the vehicle was registered and insured. The court wanted to make sure that they were going to go out there and get a vehicle that had proof of registration and insurance. They went out on September 12th, arrived there approximately 1 o'clock in the afternoon, called the number they were given for the daughter, and were hung up upon. About shortly thereafter, within the next 15 minutes, my office received a call from then counsel stating that Mr. Buckley had had a stroke and was in the hospital, and they were not going to be able to deliver the car. Well, meanwhile, they're in California. We tried to make alternative arrangements. Where's the car? Where's the keys? What can we do to, they refused to turn over the car until the following afternoon, at which point they directed my client to go to the Ventura Police Department. When she arrived there, the vehicle was virtually destroyed. Much of the interior was torn out. The knobs were super glued. The air conditioning and heat was inoperable. And most importantly, there was no insurance and there was no registration. They found out later that the vehicle had not been insured or registered since June of 2014. So they blatantly misrepresented to the court, allowed my client to go out there. My client had to incur additional expense of staying overnight, and she's left with a vehicle that was not legally operable. She got a waiver from the California Police Department. She took the vehicle home. Bailey was able to drive it home. When she went to the DMV here, she found out that previously Mr. Buckley had removed her name from the title, thus preventing her from being allowed to register and insure the vehicle. The DMV instructed her that she would need a court order from this court identifying the vehicle by VIN number, make, model, and whatnot in order to go there and get the vehicle registered, and then she can get insurance on it. Not to mention the additional expenses she's going to have to incur in doing so. They went out there and basically they defeated the order of this court by preventing her from getting what this court had ordered. And what they did deliver, just it wasn't what they were supposed to. They had to have known that they were going to run into this problem. And we had no choice but to come here. It forced my office to file this extra motion to have him held in contempt, and we would seek attorney's fees reimbursement for that. Although I'm representing the client pro bono, there's nothing in the law that would preclude me from, requesting attorney's fees based on defendant's abhorrent behavior and those of his agents that caused us to be here today. We were supposed to be here for a status check, at which point, up until opposing counsel had withdrawn, communications were good. We were both very confident that we were going to be able to get this resolved. However, when she showed up there, all she was stonewalled once again, as has been since the day that she filed this.
All right. Very good. Sir, your response?
Yes, the car was not destroyed. The middle seat was taken out. One of the middle seats was taken out, so I could access getting into the car with only my wheelchair. I have that seat in the storage. There's nothing wrong with it. As far as anything else with the car, I drove that car around. Her sister drove that car around. We had no problems with it.
Okay.
When my daughter delivered it, it was on empty. My daughter was not going to put $80 worth of gas in for her. And she told her that at the time.
Sir, do you know why it was not delivered on the 12th?
I was in the hospital here.
Okay.
I did not have anything.
Okay, but Kim was supposed to make arrangements to leave the car at her work at 4:30. She would not have to be at the hospital with you. So did you instruct her to go there?
Instructor to go where?
She was supposed to have the car at her work at 4:30 on the 12th, and she was not there. All right, this court is going to...
No, I didn't tell her that. And she was also...
Okay, all right, hold on, sir. This court is going to set it for, is granting the request for an order to show cause hearing. The court is going to include that in the trial of this matter on the order to show cause. The court would also note, pursuant to Wilfong, this court can grant attorney's fees if somebody's in a pro bono capacity. The court can look at NRS 18010 if somebody is protracting litigation unnecessarily and is not following court orders, acting in bad faith. This court would be able to award attorney's fees. We are currently set for I think our first day of trial, hold on here, is December 12th at 8:30. So, counsel, I'm going to grant your request as to the to include the order to show cause hearing at the trial. If there had been other issues of order to show cause from previously, the court is going to hear those issues also at the trial. You could put that in the order also. Additionally, sir.
Yes, sir.
You're at this point, if you need to get counsel to continue to represent you, you're going to have to make arrangements for that. This court, if you're not going to be able to appear here physically, you're going to have to get a letter from your doctor, and you're going to have to provide proof to the court that you cannot appear here physically. If you cannot appear here physically, this court would allow you, sir, to appear by way of video conferencing. You would have to make arrangements in California somewhere where you could set up a video conferencing, and you would have to make arrangements with the court so we could do that at the same time. That's going to have to be set up at least a week in advance, sir. What I am saying is you are the only one who would be able to appear by way of video conference. If you're going to have other witnesses, they have to appear here in court. They have to be in front of the courtroom, at the courtroom, where they could be subject to cross-examination, and this court can observe their demeanor and their conduct here in the courtroom. The only reason I am allowing you to appear by video conferencing is if you have a doctor's letter specifically stating that your condition does not allow you to travel here in order to testify here in court. Otherwise, if you don't have that letter, this court is going to request. And I should have that letter within the next 3 weeks. No, let me see, time-wise. Would be
All right, I'll try to get counsel. I don't have the money to do it, so I don't know what I'm
By
going to do.
November, sir, by November 10th, I need a letter that you have to provide to the court. Counsel will provide you a copy of it from your doctor saying you cannot physically be here. And that date again, it is no.
Oh,
December 12th, and we are set at 8:30. Again, you are the only one who is given that permission if you have a letter from your doctor saying you cannot be here. By November 17th, sir, you're going to have to call, if in fact you have provided the letter. I'm going to give you a number. It's 702-455-0520. I believe you have called or somebody has called on your behalf. That is my judicial executive assistant, Karen. And you would have to provide the information as to where the video conferencing would take up, and so that we could then get your information to our the IT department of the court system, so they can make sure and probably do a trial run before we go to trial on this case that it's in fact going to work, the video conferencing. So again, that's by November 17th, no later than 5 p.m. Counsel?
Your Honor, there's a couple more things that I may have glossed over. He still has not paid the mortgage on the house. My client is now receiving default letters from the mortgage company. They can't get a hold of him. They don't know. They don't have his address. They have no way. So they're sending my client these default letters, but yet they still won't talk to her about the account. She is in the process of having the tenants removed. She's going through, unfortunately, she has to do an unlawful detainer because the defendant has told the tenants that they don't have to move out. So we're running into these additional problems.
All right. We already have...
Your Honor, the paper she filed on the tenants in there was an illegal action. She didn't do it properly.
yes, I did.
All right, sir. The order of this court is that those tenants were supposed to be out of there, and you were supposed to make that payment because you received the money for that.
All payments are made.
All right. This court is issuing an order today that, at least on a temporary basis, that as quickly as she can get immediate exclusive possession of that home, and if there's some, eviction that she's going to have to go through, that is she is to have immediate physical possession of the home, and additionally, she is given sole discretion regarding working with the bank on addressing these issues so that home is not lost, and that she can make whatever arrangements that she needs because that's a community asset that needs to be protected. And by way of the order from today, this court is going to give her that ability to do that. Okay.
I'd like to know how she's able to make payments in that house.
And Your Honor, we would also further request that today's order would include the direction to the DMV so that she's allowed to register.
Absolutely. This court is at this point. This court is giving her legal rights to that vehicle, where she would be able to register it, get insurance on that vehicle. Ultimately, at the end of the day, and again, this court is giving her that right today. At the end of the day, this court can look at the entirety of the community, any property that they have, any property that was allegedly, taken or mismanaged, and this court ultimately would be able to, if necessary, do an unequal distribution of community assets. The law allows me to do that, but I can't do that today. I can just put in place orders that will allow her to get into that property and drive that car, because it was pursuant to stipulation that he was going to register the car, have insurance on it, and he was going to provide the vehicle on that day, and that certainly has not happened, and that's why this court is issuing these orders. Other than that, sir, we are set for trial on December 12th at 8:30. Counsel, I'm going to have you prepare an order from today.
Yes.
My court clerk will review it, and if it's accurate, I will sign off on it and get it back to you as quickly as possible. And then you can...
Your Honor?
Yeah.
Your Honor?
What? Yes, sir.
She signed a quick claim deed on that property. All my properties, everything I own, back to me.
All right, sir.
What?
I
Yes.
I am putting an order in place today to allow her to communicate with the bank and make arrangements so that home is not lost. I'm trying to protect an asset. There's an assumption that if something has been obtained during the time of the marriage, that is community property. You may have a legal basis as to a quitclaim deed. That I do not, but that's not that would be a trial issue at the time that we start this trial on December 12th. In the meantime, I'm going to protect that asset so it doesn't get lost. So, counsel, I'm going to have you prepare the order, and do we have a calendar call set on this matter? Okay, so we'll 8:30. So we will be back in court on December 1st at 8:30 for a calendar call. And counsel, I'm going to have you prepare the order from today, and we'll see where things end up. Okay? All right.
Thank you, Ron.
You're welcome. Off record.